Comey, during questioning earlier, there was a dispute that arose over the contents of one or more of the immunity letters that were issued, particularly with regard to the issue of whether or not it contained immunity for destroying documents, emails. The individual who was questioning you about that was former Chairman Issa of the Oversight and Government Reform Committee, and I want him to be able to clarify, because we have contacted the Department of Justice and asked them to read the immunity letters to us. So the gentleman is recognized briefly.
Thank you, Mr. Chairman. I'll try to be very brief. Under the immunity agreement with one or more individuals, we'll use Cheryl Mills as clearly one of the individuals. She negotiated a very, very good deal from what we can discover. She did not just receive immunity related to the production of the drive, the computer, and the contents, but in fact received immunity under 793, 18 U.S.C. 793 E and F, 1924 U.S.C. 1920, 18 U.S.C. 1924, and the so-called David Petraeus portion, 18 U.S.C. 2071. And I'll focus on 2071. Her immunity is against any and all taking, destruction, or even obstruction, the way we read it, of documents classified or unclassified. Now, the only question I have for you is, and I know you're going to put this to justice, and we may have to ask them separately, for the purposes of what you needed as an investigator, because you were the person that wanted access to the computer, is that deal make any sense to, in return for things which she could have objected to as an attorney and held back, but which had no known proffer of leading to some criminal indictment of somebody else, she received complete immunity, as we read it, from obstruction or destruction of documents classified and unclassified, and that's based on a re-review of the immunity agreement.
Yeah, I think this is you're right. This is a question best addressed to Justice, but I think you're misunderstanding it. As I understand it, this was a promise in writing from the Department of Justice. If you give us the laptops, we will not use anything on the laptops directly against you in a prosecution for that list of offenses. It's not immunity for those offenses if there's some other evidence. Now, that said, I'm not exactly sure why her lawyer asked for it, because by that point in the investigation, we didn't have a case on her to begin with.
Well, I understand that, but based on the Reddit discovery and others, they asked me to do it, and you said so yourself. It was probably Cheryl Mills, they. You have an immune witness who has to tell you who they were. If they were told me to delete, and that's Cheryl Mills, then in fact you have evidence from an immune witness of a crime perpetrated by Cheryl Mills, the ordering of the destruction of any document classified or unclassified, which clearly she seems to have done.
But she wouldn't be protected from that. If we developed evidence that she had obstructed justice in some fashion, all she's protected from is we can't use as evidence something that's on the laptop she gave.
So with the
prosecutor.
Right. So the information put into the record today, which included these Reddit discoveries, show that there is a they who asked to have the destruction of information under 18 U.S.C. 2071. If she doesn't have immunity for that order, she could, and by definition should, be charged, because ordering somebody else to destroy something as an attorney well after there were subpoenas in place that were very specific, that's clearly a willful act, isn't it?
Mr. Chairman, would you yield?
Of course.
Your line of questioning, first let me show my cards. I believe that Cheryl Mills has an impeccable character, as my line of questioning suggested that Director Comey and his staff have impeccable character. But my good friend, there's immunity given. I don't think this applies to Ms. Mills, and I looked at the sections that you're speaking of. If you take local criminal and state actions given to the worst of characters for a variety of reasons, that was not the reason given to Ms. Mills. I am assured that it is a lawyer that was trying to be the most effective counsel to Ms. Mills as possible.
Well, reclaiming my time, the gentlelady's point may be true. I'm only speaking to the director based on things were done that should not have been done. We now have evidence in front of this committee in the record of people destroying records of activities as late as a few days ago. So the fact that there still should be an open question, first of all, is could she be prosecuted? And if, in fact, they have told me to destroy this, under the exact same statute that included David Petraeus's, who was no longer on active duty, 18 U.S.C. 2071, there's at least a case to be made. Now, the problem we have is the lawyer negotiated a set of terms which hopefully doesn't mean that she gets a free pass, even if she willfully ordered the destruction of documents, which it does appear she did. And look, my job is not to be judge, jury, or hangman. My job is to look at what's been presented to us, ask the highest law enforcement officer in the land to, in fact, look into it, because it does appear as though it is there.
A brief yield, my good friend.
Of course.
Certainly, we have an oversight responsibility of the director. I think he's been very forthright. But none of the actions of destruction can be attributed. I don't think we have anything in evidence to suggest that Ms. Mills contributed to the dictating or directing.
Well, the gentlelady may not have been.
Destruction.
The gentlelady may not have been here.
We can't speculate here.
The gentlelady may not have been here at the time, but the director himself, when asked who would they would have been in that order to destroy, at least said it probably was or likely could have been Cheryl Mills. We're not saying it is. What we're saying is you have an immune witness.
The gentleman will suspend.
Of course.
The purpose of this was to set the record straight as to what the content of the document was. That has been accomplished, and the debate will continue on. But it will continue on outside of this hearing room.
And I would only
ask, speculate.
And I would only ask that the director be able to review those documents at justice and follow up with the committee. Would be very helpful to all of us. I thank the chairman.
The director has answered in the affirmative that he will do that.
Yes, we'll follow up.
First of all, I want to thank Director Comey. We didn't make 4 hours and 40 minutes, but we did almost make 4 hours, and I know you have been generous with your time. However, I will also say that I think a lot of the questions here indicate a great deal of concern about the manner in which this investigation was conducted, how the conclusions were drawn, and the close proximity to that, and the meeting of the Attorney General with former President Clinton on a tarmac. At the same time, she then said, well, I'm going to recuse myself, and then shortly after that, you took over and announced your conclusions in this case, which are hotly disputed, as you can tell. The committee and the Oversight and Government Reform Committee have referred to the United States Attorney for the Eastern District of for the District of Columbia, referral based upon her testimony before the Select Committee on Benghazi, suggesting that your statement at your press conference and your testimony before the Oversight and Government Reform Committee very clearly contradicted a number of statements she made under oath before that committee. And I want to stress to you how important I think it is that we made that referral for the purpose of making sure that no one is above the law. And in many cases regarding investigations, it is not just the underlying actions that are important, but they are the efforts of people to cover those up through perjury, through obstruction of justice, through destruction of documents. And so I would ask that this matter be taken very, very seriously as you pursue whatever actions the Department chooses to take, making sure that no one is above the law.
Thank you, sir.
With that, it concludes today's hearing, and I thank our distinguished witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record, and the hearing is adjourned.